Have you been treating for a medical condition and have changed employers and now think you might be able to file a disability insurance claim? So let's say you got a great job about a year ago, despite your medical problems, and you've now enrolled in your employer's ERISA disability insurance policy or plan. You might, for example, have been struggling with fibromyalgia, POTS, long COVID, or any other disabling medical condition, and you've been getting treatment. The question becomes, can you file for short and long-term disability benefits if you can no longer work once you're enrolled in their disability insurance policy or plan? You might be tempted to do that. I have to say to you, let's rewind this, because that whole thing can be disastrous. Many short or long-term disability policies or plans have provisions that are called a look-back period. So if you recently enrolled in a disability insurance coverage, that provision is going to require the disability insurance carrier to look back to determine whether or not you got treatment for your pre-existing disabling medical condition in that relevant look-back period. And that's generally based on the effective date of the policy. The length of the look-back period can vary, and that's why you want to get a copy of your disability policy or plan. But if the carrier finds that you've been getting treatment, visiting a doctor, taking medication, you legally are going to be denied your disability benefits on the basis that it's excluded under the pre-existing condition clause. So let me give you an example. Let's say you became employed January 1st, 2023. You've had sporadic treatment in the year before for what would have become your disabling condition. You become eligible for your short-term benefits on April 1st, 2023. Now, despite your ongoing medical problems, you've continued to work until December of 2023, and you have to stop. Now you apply for your benefits. Unfortunately, you didn't look at the disability insurance policy or plan before you stopped work. You didn't know that if you got treatment for the year prior to the effective date of the coverage of April 1st, 2023, you would have no coverage, and your claim can and will be legally denied. So if you're going to change employers while you are treating for a potentially disabling condition, I think you need to think twice. And if you do get a new job, you want to look at that disability insurance policy or plan to see when's the effective date of your coverage, whether there's a look-back period, how long it is, what's considered to be treatment, how long you have to go without treatment before the pre-existing condition clause isn't applicable. And you better read your medical records, because you want to determine what your physician is reporting about your complaints, your diagnosis, and your treatment. And you want to get a copy of the pharmacy records to see what prescriptions have been filled. Why? Those are all the things that disability insurance carriers are using in an attempt to deny a disability claim based on a pre-existing condition clause. These steps can make a difference in whether or not you're going to get your disability benefits and whether or not you want to even think about changing jobs and getting a new disability coverage. So think. If you have any questions about your rights to ERISA disability benefits, particularly if you have a pre-existing condition that you're treating with, call me at 727-894-3188 for a complimentary consultation.